Hello, and welcome to Mayer Brown's webinar on resolving license disputes through arbitration, U.S. and international. My name is James R. Ferguson, and I'm a partner in Mayer Brown's Chicago office, where I focus my practice on intellectual property, complex commercial litigation, and domestic and international arbitration. Joining me today as my co-presenter is Dara Kurlancheek. Dara is an intellectual property partner in Mayer Brown's Washington, D.C. office. She is a registered patent attorney whose practice focuses on complex patent litigation and domestic and international arbitration. Before we begin, we'd like to mention a few housekeeping announcements. First, as noted under the FAQ widget on the right side of your screen, today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presentation. Lastly, regarding CLE credit, we will be providing an alphanumeric code during the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. These forms are also available to download on the right side of your screen under Resource List if you need them. With that said, let's get started as my partner, Dara Kurlancheek, will begin our presentation.
Thank you, Jim. I'm going to start out today by giving you all a high-level overview of what we will be covering before we dive into the details. First, we're going to go over the key characteristics that are common to many licensing disputes, which is why arbitration, and specifically international arbitration, comes up so frequently when resolving these types of disputes. Second, we are going to discuss what happens once a dispute has arisen between you and another party to a license agreement. Specifically, we will go over some of the important strategic decisions that will need to be made in the arbitration, from the selection of arbitrators to the scope of discovery to the use of witnesses. Third, once you're familiar with some of the important aspects of the arbitration over the license dispute, we will discuss how the decisions you make when drafting the arbitration clauses in your license agreements can help set you up for an arbitration with attributes that will be beneficial to your specific situation. So let's dive in. First, we will quickly go over some of the key characteristics of license disputes. License disputes involve all types of intellectual property, including patents, trade secrets, copyrights, software, and trademarks. Sometimes more than one type of intellectual property is involved in a license, and sometimes you'll find that more than one type of intellectual property will be involved in the dispute. It depends on how far off track from the original license the parties have gone. Because of the nature of patents and software, there are frequently highly technical facts involved in the dispute. Whether it be dealing with the scope of the patents or the technical scope of the license, the operations of the licensed products, or even the validity of the patents themselves. In addition, there is almost always a dispute over payments, or lack thereof, or a dispute over the way in which payments were calculated. So accounting or auditing issues are a common theme in these disputes because, let's face it, the bottom line is people are always fighting over the bottom line. Because of the highly technical issues and the accounting and auditing issues present in licensing arbitrations, there is usually substantial expert testimony presented. And as Jim will discuss a little later on, that expert testimony has an even more significant role in arbitration than it would in a normal court litigation proceeding. There can also be claims for equitable relief because, as we all know, sometimes money isn't just going to solve the problem. Finally, arbitration as the dispute resolution method. License agreements don't have to contain an arbitration clause. But because of some of the benefits we're going to discuss today, it's fairly common for parties to consider frequently designate arbitration as the dispute resolution method for at least some of the potential disputes that could arise from the license. So briefly, here's a list of some of the different types of intellectual property that may be at issue in a license dispute. As you can see, this includes patents, trade secrets, copyrights, and trademarks. It is possible to license any or all of these types of intellectual property, and wherever a license may occur, a dispute may occur. There are a few key disputes that we see arise out of license agreements over and over again. First, unpaid royalties. A party just doesn't live up to their end of the bargain or fails to pay the royalties that are due under the license. Next, there can be a misappropriation of the IP that was granted in the license, such as trade secrets, or infringement of other intellectual property. This happens when the license permits the use of intellectual property for a specific purpose, and then the licensee uses that IP in a way that was not granted in the license. The scope of the license can also be a big issue. For example, in tech licenses, where there may be a few hundred patents as part of the license, the parties do not want to make infringement the test to see if a license payment is due. That would result in hundreds of infringement tests and would take up a lot of everyone's time. Instead, the parties can define a set of specific features that, if they appear in a licensee product, would then require a license payment. However, sometimes the scope of the license that's defined there can be in dispute about whether or not a specific set of features is actually covered when it comes time for payment on a licensee's product. There can be other types of breaches of contract too, such as failure to report, failure to comply with audits, or the use of intellectual property outside of the territory where use was granted. And of course, there are always damages. I will now hand it over to Jim Ferguson, who will discuss some key strategic decisions in a license dispute arbitration.
In this next section, we're going to look at some important decisions that have to be made once a dispute has arisen. So, in this next section, we're going to examine the key strategic decisions that are made during the course of arbitrating a license dispute. Recall that the scenario here is that the parties have already entered into a license agreement, the license contains an arbitration provision, and a dispute has now arisen. At this point, what are the key strategic decisions that need to be made? Each of the major questions we've highlighted on this slide in the bullet points that are identified. The first key strategic decision: what claims do you want the arbitrator to decide? What preliminary injunctive relief, if any, will be needed? What are the major factual and legal issues in the dispute? What arbitrators should be selected? What kinds of experts should be retained? What kind of discovery is needed? And finally, what is the most effective way to present testimony at the arbitral hearing? So let's look now at the first of these key strategic decisions. The key question here is whether you, as the claimant or the respondent, want the arbitrators to decide some, all, or none of the claims in the dispute. This decision will have to be made at the very beginning of the dispute, whether you're the claimant or the respondent. There are a couple of possibilities here. You may not want the arbitrator to decide all of the claims in the dispute, or perhaps you don't want the arbitrators to decide any of the claims in the dispute. In this situation, your next step is to decide whether or not you have a factual or legal basis for a motion to dismiss. Another scenario that might arise is a situation in which you want the arbitrator to decide all of the claims in the dispute, but the opposing party has filed a court action. And in that circumstance, you will need to consider a motion to compel arbitration before the court. So this is the kind of assessment that must be taken at the very beginning, and it's among the earliest strategic decisions you'll have to make in arbitrating a license dispute. A second critical strategic decision focuses on whether preliminary injunctive relief is needed. License disputes are particularly prone to emergent situations requiring injunctive relief to preserve the status quo before an arbitral tribunal has been constituted. We identify a couple in this slide: the misuse of proprietary information, for example, or the threatened removal of relevant evidence, or, more commonly, a licensee who has failed to fully comply with the audit requirements. In this type of situation, you should consider two possible options. The first is injunctive relief from a court. Many, if not most, states have statutes authorizing injunctions in aid of arbitration, and so this may very well be an option if injunctive relief is needed. The second option is injunctive relief from an emergency arbitrator appointed by the administering institution. By administering institution, we mean institutions like the American Arbitration Association or the International Chamber of Commerce, which are often specified in the arbitration clause to administer the arbitration. These institutions all have provisions authorizing the appointment of emergency arbitrators on short notice. So either of these options should be considered if preliminary injunctive relief is needed. Strategic decision number 3 centers on identifying the major factual and legal issues in the dispute. As Dara noted, most license disputes present a wide range of legal and factual issues. For example, there are often contractual issues that center on the meaning of disputed contractual terms. There are frequently accounting and/or audit issues. Almost invariably, a license dispute will involve some form of technical issues, as well as other factual disputes, and of course, there are damages issues. An early assessment of the legal and factual issues and an identification of each of those issues is important not only for the preparation of the case, but also for the resolution of several other critical strategic decisions that we're going to address. Strategic decision number 4 focuses on the selection of the arbitrators and poses the question, what arbitrators do you want to decide the dispute? The importance of this question cannot be overstated. Indeed, it is a potentially outcome-determinative strategic decision that's made at the very beginning of the arbitration. Remember, our scenario is that the parties have entered into a license agreement. The license agreement specifies the method of selecting the arbitrators, and a dispute has subsequently arisen. In most cases, the arbitration provision will specify one of two broad methods of arbitrator selection. The first is party-appointed arbitrators, which is the subject of this slide. In the case of party-appointed arbitrators, each of the parties selects an arbitrator for a panel of 3, the so-called wing arbitrators, and then the 2 wing arbitrators select a chair. The parties have the ability to interview candidates for their party-appointed arbitrators, and in our experience, the interview is critical. One of the most important questions to ask during the interview is, what is the candidate's understanding of her role as a party-appointed arbitrator? Here, there are 2 broad possibilities. One, the candidate may see her role as being completely independent and neutral. The second is the candidate may see her role as ensuring that the positions of the party that appointed her are understood by the other arbitrators, but making clear that she is not predicting or guaranteeing that she will ultimately rule in favor of the party that appointed her. We always opt for this second candidate. We have to assume that the opposing party is similarly looking for a party-appointed arbitrator who will articulate their positions to the other arbitrators, and so at a minimum, we're looking for an arbitrator who will fulfill the equivalent role. This means that the goal is to select an arbitrator who will be receptive to, or at least understand, our case, and persuasive in presenting the merits of our case to the other arbitrators. So the desired attributes of a party-appointed arbitrator are experienced, respected, and a reputation for collegiality. The second common method of selecting arbitrators is a provision that calls for the administrating institution to play a role in the arbitrator selection. And typically, the parties will have input into this selection. What often happens is that the administrating institution will provide a list of conflict-free neutrals to both parties. In the so-called strike and rank method, each of the parties will have the right to strike up to 2 or 3 of the candidate neutrals and then to rank the remaining neutrals. The administrating institution will then review the submissions of the 2 parties and select the 3 candidate neutrals who have the highest combined scores. So in this way, you get a panel of genuinely neutral decision makers. None of them will know exactly how they were ranked by each of the parties. The desired attributes that we recommend are again the same: experienced arbitrators, respected, with a reputation for collegiality, because remember, the goal is to reach a consensus. One interesting question that often arises in this circumstance is whether or not you want to select arbitrators who have a background in the relevant technology or the area of the law, patent law, for example. And in many cases, the arbitration clause will include a provision requiring this background. 2 potential risks that we want to highlight. While there are obvious strengths to selecting arbitrators who are knowledgeable in the technology or the area of the law, there are 2 potential risks. One, a smaller pool of candidates, obviously, will be available, and that increases the risk of disqualifying conflicts. More substantively, if you select an arbitrator who has a background in the relevant technology or area of the law, that arbitrator is likely to have what we describe as deeply ingrained ideas in the areas of expertise. Most individuals who spend a career in a particular field have a pretty good idea of how they think things should work. The risk is that these deeply ingrained ideas may not align with your theory of the case, and of course you'll have no way of knowing that until the arbitration is well underway. So for those reasons, I at least have a bit of a bias towards an experienced commercial arbitrator as opposed to an arbitrator who has relevant background, but again, the arbitration clause itself may limit the choices here. We come now to the 5th strategic decision, and that is selecting experts. Experts in the arbitration of licensing disputes play a critical role. They have an enhanced importance because so many issues have a technical component, as Dara mentioned. We have typically accounting and audit issues, relevant technology issues, damages issues, and what we refer to as the economics of licensing issues. I'll return to that in a second. So, given that experts play such a critical role in arbitration, what kinds of characteristics are we looking for? Our suggestion is to consider not only technical competence, which goes without saying, but also experts who have a deep background in providing testimony, particularly in arbitrations. Arbitrations are very different from litigation in courts before juries because the decision makers are experienced commercial, typically lawyers. And as a result, the hired gun criticism that might get some traction with the jury is not going to have any traction with commercial arbitrators. So experience is a very important consideration, and that's particularly true because this phenomenon of hot tubbing has become so common, not only in international arbitrations, but increasingly in U.S. arbitrations. Hot tubbing refers to the situation in which the experts from the opposing parties appear before the tribunal at the same time, and they field questions from the tribunal. And in many cases, the tribunal will have asked the experts to meet and confer in advance of their hot tubbing testimony to try to narrow the points of disagreement, and the exercise becomes then an attempt to persuade the arbitral tribunal of the merits of their respective positions. So an expert who has had experience in hot tubbing, particularly experience that was successful, is an expert that should be strongly considered as a candidate for your case. So when we're interviewing experts, we are very interested, potential experts, we're very interested in learning about their background in arbitrations and particularly their background in the hot tubbing scenario. Strategic decision number 6 focuses on the discovery that is needed in the case. The discovery question is particularly pressing in arbitrations because arbitrations typically impose far more stringent limitations on discovery than does litigation. In international arbitrations, for example, there are no depositions, and document production is only from the parties and only on a showing of demonstrated relevance. U.S. arbitrations are not much different. Any depositions are typically limited to the parties and or their experts. In other words, there is no deposition of third parties. And document productions are limited to documents having a demonstrated relevance to the issues in the case. What this means is that you must work with your experts to identify the specific evidence that you need to support your theory of the case. We arrive now at the 5th strategic decision, which focuses on the effective presentation of hearing evidence. What is the most effective way to present your case at the arbitral hearing? Our recommendation here is that the party focus on the development of 2 or 3 unifying themes and use those themes based on fact and expert testimony, and in particular relying on 2 or 3 experts as the pillars of the substantive case. These experts will typically be an accounting or audit expert and a technical expert. In addition, if a case turns on disputed contract terms, the use of a licensing expert to support contract interpretations can be very effective. Now, obviously, if the language of the agreement is straightforward, there will be no dispute about the meaning of the terms, but in licenses in particular, it's not unusual to encounter party disputes over the meaning of critical terms, and it's in this context that the testimony of a licensing expert as to the economic rationale for one party's interpretation over the other can sometimes be extremely persuasive. To illustrate the use of a licensing expert to support contract interpretation, we have this example of a so-called stacking provision. A stacking provision provides for royalty deductions if the licensee has to pay royalties to a third party in order to use the technology that's licensed from the licensor. In one case, the licensee argued that this stacking deduction should apply to royalties it continued to pay for third-party licenses it entered into before the parties negotiated the agreement in question. Our licensing expert explained that the economic rationale for a stacking deduction applies only to third-party royalties not in existence at the time of the negotiations. If the third-party royalties are in existence at the time of the negotiations, the licensee can take them into account in negotiating the royalty rate. So in this way, our licensing expert could identify an economic logic that supported our interpretation of a disputed contract term, and that turned out to be very persuasive. We've just reviewed 7 key strategic decisions that must be made in arbitrating a license dispute, and these strategic decisions provide a really useful backdrop to reviewing what kind of provisions should be included in drafting an arbitration clause for a license agreement. And Dara is now going to explore that subject.
Thank you, Jim. So now that you are familiar with some of the strategic issues that arise during the course of a license arbitration, we're going to go over some of the things to keep in mind when you are drafting the arbitration provision of your license agreement, with the hope of putting you in the best possible position for the arbitration should a dispute arise between the parties. Now, we have been asked before, can you just provide an arbitration clause for us to have on hand, keep in our back pocket to use in license agreements? But the truth is, each one needs to be designed for the specific situation. And it can be difficult when you are drafting a clause to anticipate what exactly your needs will be if a dispute arises. Because you don't always know what the breach or disagreement may be, you don't know if you are going to be wearing the white hat in the situation and want a lot of discovery from the other party, or maybe if this time you would be in a situation where it would be better off to limit discovery. So the best you can do is make educated decisions based on the circumstances surrounding the license agreement at the time it's being drafted. These considerations are what we are about to go over and will help you with that. So there are several strategic issues to consider during drafting. For example, if the companies are located in different countries, then international arbitration definitely has a distinct appeal. You don't want to have to worry about getting jurisdiction over the other party in your home court, nor do you want to get stuck in a litigation in a foreign court. With your arbitration clause, you can agree ahead of time on an arbitration organization such as the ICDR or the ICC to be the host of the arbitration. You can also decide ahead of time on a location, including a neutral location if you prefer, for the arbitration to take place. If the importance of the license agreement, the importance of the license agreement can also factor into the decisions made for the arbitration clause. For instance, if the dispute over the license would be incredibly important to the company, then you're more likely to want a 3-arbitrator panel because you'll want to avoid the risk of there being a lone arbitrator going rogue, and cost in that type of situation would be less of a concern. You'll also need to consider how important confidentiality is to your client. This is an important issue that we're going to discuss in a lot more detail shortly. Similar with discovery, do you think you will want there to be depositions? Do you think that you will want there to be extensive document production? These are all important things to think about and that you can address ahead of time in your arbitration clause. Another issue is cost. Clearly a benefit that people are always aware of is that arbitration can have a much lower cost and a faster speed than normal court cases. But the number of arbitrators and the scope of discovery that you decide upon will directly impact that. Similarly, you may want to preserve your rights to keep protections for equitable relief from a court, and Jim will speak to some of the deterrents that you can put in place to keep a long-term relationship between the parties more stable in a little while. So what we have here on this slide is a really good checklist of topics for you to go through when you're drafting an arbitration clause in a license agreement. And we are going to discuss each of these in turn. But for a high-level idea, it's good to look at the scope of the issues. What is it that you actually want the panel to have the power to address? You need to understand what procedural rules and governing law and venue you're going to have, all of which can affect the proceedings. How the arbitrators are selected. Jim talked about this a little earlier, and we'll go into it in a little more depth later, but the qualifications of the arbitrators and the procedures used to select them will have a big effect on who you end up with running the panel. What remedies the arbitrators can impose. You have a lot of power when you're drafting this arbitration agreement of what you want to allow them to do, what you can prevent them from doing, and what you want to compel them to do. The scope of discovery, as I mentioned before, you can make it very limiting or more permissive. The hearing procedures. How much do you want laid out ahead of time, and how much do you want to allow for the panel to decide once the dispute itself has arisen? And confidentiality, this is a big one that we'll talk about a lot later, but you need to think about that for both the proceeding and the award, and also about your options for enforcement. So the first item on that checklist is the scope of the dispute. You can decide early on, do you want all of the issues that may arise from this license agreement to be resolved by arbitration? Now, some benefits to this are, you know that everything that comes out of this, anything that comes up between the parties, will go directly to arbitration. There won't be a split dispute where some of the stuff is in court and some of the stuff is in arbitration with the arbitration panel. And when you do that, it can be more cost efficient and you can get to a result faster. Also, if you want to keep everything with the arbitration panel, then you may end up with a final decision much more quickly, which also means that there may not be any room for appeal. So that's something to keep in mind. Another option is to limit the scope that the arbitration panel or arbitrator may address by picking specific items that you don't want them to address, like patent validity. You may decide that only IP issues are going to be heard by the panel, but breaches of contract would go to a court. You can split them up any way you want to, depending on the law that you're using and the timing, speed, and cost. Another option is to carve out certain issues, like equitable relief for a court. And the note on this slide, I think, is particularly interesting because some people are hesitant to go forward with the arbitration as the only method for resolving their disputes because it's so final and there's no method for appeal, and you can't really go outside of that in certain circumstances. But if you have carve-out items, then you have the ability to facilitate injunctive relief or compel compliance with, for example, audit requirements. And that way you're kind of hedging against the risk of an arbitrary decision by an arbitrator, which some in-house counsel find a little reassuring kind of as an insurance policy. Another item on the checklist is deciding the governing law, venue, and administrator of your arbitration. And these all will have a very distinct effect on how your dispute will be resolved. For example, if you are the licensor, you will want to select governing law that is protective of IP rights. For example, in New York or Delaware, where trade secrets are well protected. Another consideration are the discovery rules there. For example, you may want a venue that has strict parole evidence rules to keep out discovery on lengthy license agreement negotiations. However, I will note that arbitration is kind of the wild, wild west. So arbitrators may decide, even if under technically the rule of law and evidence and where you've selected, parole evidence should not be considered, arbitrators may decide, and I have seen them frequently decide, to allow all evidence that they want to hear in and announce that they will give it the weight that it is due and address, for example, the exclusion of the parole evidence in their final award or in their decision, but while still allowing it in at the hearing. So you never know if that's going to come into play as well. But when it comes down to the weight they should give it, you'll have that strong law behind you if you so choose. Another issue is the administering institution, like, for example, the ICDR. You can incorporate by reference the institution's rules that the arbitrators would then follow during the course of the arbitration, and that can affect the timing. It can affect the number of hearings you have in terms of administrative stuff leading up to the final hearing, and can affect the discovery.
One other important item on our checklist of arbitration clauses is addressing the qualifications of the arbitrators. We saw in our discussion of the strategic decisions that have to be made during the course of an arbitration how important it is to select arbitrators that are best calculated to be receptive to your case. At the time that you're drafting the arbitration clause, you have an opportunity to address this situation. A couple of alternatives here. First, as we've seen, the arbitration clause can require that the arbitrators have experience in the relevant industry or the area of law. Another option is to impose restrictions on nationality, particularly in international arbitration. You frequently see arbitration clauses that restrict the neutrals from being based in the countries of either of the two parties. And then finally, you can have no requirements or restrictions specifically spelled out in the arbitration clause. As we discussed in reviewing the strategic decisions, selecting an arbitrator with experience in the relevant industry or technology has both strengths and weaknesses. The strength being that you will have an informed and knowledgeable decision maker. The weakness is that the decision maker may have a mindset that's not consistent with your theory of the case and may be difficult to overcome. So these are the kinds of nuanced judgment calls that have to be made in defining how the arbitrators will be qualified. We also saw in reviewing the strategic decisions that are important during the course of an arbitration that the selection of the arbitrators is extremely important and potentially outcome determinative. This is another item on the checklist that can be addressed in drafting the arbitration clause. We reviewed the two major alternatives in discussing the strategic decisions. One alternative is the selection by the administrator, who will compile a list of conflict-free neutrals. The parties then have input, for example, the strike and rank that I described earlier. And as I also mentioned, this approach is best calculated to create a genuinely neutral panel. Party-appointed arbitrators allow each of the parties to select one of the wing arbitrators, and the two party-appointed arbitrators then choose a chairperson. Somewhat to my surprise, I have learned that many clients prefer party-appointed arbitrators. As a litigator, you might prefer to have three neutrals genuinely independent without any form of allegiance to either of the parties. But I found that many clients actually prefer party-appointed arbitrators because they want the comfort of knowing that there will be someone who will ensure that their position is articulated to and understood by the other two arbitrators. Again, with party-appointed arbitrators, there's absolutely no guarantee that they will ultimately rule your way, but there is an expectation that they will at least ensure that your position is understood by the other two arbitrators.
We're now going to go to the next item on the list, which is confidentiality. I really want to go over the background for this in detail because I find it is one of the most common misconceptions that people have about arbitration. frequently people believe that one of the benefits of arbitration is the inherent confidentiality of the arbitration proceeding. And what's true about that is the arbitration is not public. So normally if you file a case in district court, we all know that that's public information. Anyone can go look that up. When you file an arbitration, it's through a private organization. The public cannot go and look that up. Only you, the other party, and the arbitration organization that's administering it know that this has been filed, and no outside organizations can go in or investigate if there has been any dispute between the two parties. The administrator of the arbitration will not disclose that to anyone. So it's not public. However, there's not automatic confidentiality when it comes to the arbitration. And what I mean by that is you and the other party are not automatically bound to keep the existence of the arbitration or what happens during the arbitration confidential unless there has been an agreement as such between the parties. For example, in the ICDR, there is no specific provision that requires the parties to keep the existence of the arbitration confidential. So there are two ways in which to keep the proceeding itself confidential. One is to address that in your arbitration provision in the license agreement. And the second place where the parties may be able to reach an agreement on confidentiality is if they decide to enter a protective order during the course of the arbitration. But what's important to look at is there are three different aspects of confidentiality that you may want to address. The first is the existence of the arbitration. That's the fact at all that the parties are in a dispute. Do you want that to be confidential, a fact in and of itself? The second is confidentiality of the substance, the materials that are being exchanged, and what the dispute is about. And the third is the confidentiality of the award itself. Is the outcome of the dispute confidential? Is what comes out of this going to be something that the parties can disclose publicly? And so those are all things that can be addressed in your arbitration provision, in addition to specific confidentiality requirements for discovery, such as returning all discovery to both parties after the dispute is over, or requiring documents relating to the dispute or the arbitration to be destroyed once it is over. And something that is important to think about if you believe that this information is very important and very confidential and you don't want it to be public at any point, is that if you are concerned ever about enforcement of an award in an arbitration, you want to consider if the award may be filed with a court that may then become public, in which case you may want to make sure that the arbitrators only issue a bottom line award that doesn't have any detail or explanation for why they reached their decision. And that's something we will talk about in a little bit. Another thing to address in your arbitration provision is discovery. As I mentioned earlier, you're not going to know at the time you're drafting this licensing agreement what the dispute is going to be when it finally arises. When you're entering the agreement, you're hoping there's not going to be a dispute. So once one pops up, you don't know how much discovery you are or are not going to need. The one option is to just leave it to the arbitrator's discretion. You don't have to include provisions relating to discovery in your arbitration provision. However, there are other options. One of the main benefits of arbitration is the ability to limit discovery and therefore limit costs. And so you may want to say that there's not going to be any discovery. You may want to say that there will be, for example, no depositions Or you may want to say there are no depositions unless there is a shown need proven to the panel. That way there's a little bit of wiggle room if you decide to, down the road, that a deposition really is important, but it provides the panel with some guidance that the parties didn't intend for this to be something to be used at will and in overabundance, something that should really just be used for a very important situation where it's necessary. Similarly, you can put in limitations on timelines, such as all documents must be exchanged within 4 months of the arbitration panel being seated, or a limit on the number of document requests. There are a lot of ways to kind of limit the cost and limit the amount of discovery. And again, you can always try to provide guidance to the panel with how limited you want the discovery to be, but then say that the panel has the discretion to change this if needed, so that if unforeseen circumstances arise, they have the ability under the provision from the parties to change that. Similar to discovery, when it comes to drafting clauses related to hearing procedures, you can choose to be very specific and limiting and leave very little up to the arbitrators, or you can leave it to the arbitrator's discretion so they can make decisions based on the circumstances at the time. You will have already chosen a venue and governing law for the license agreement, but you can also choose the rules of evidence that the panel should apply at the hearing, such as the IBA rules of evidence, or you could leave it with the rules of the venue which you have chosen. You can also choose to limit the number of witnesses that a party may present at the hearing, or limit the duration of the hearing in total. For example, you could say that the hearing will take no longer than 3 days in order to put a limitation on it. One thing to take into consideration is the importance of the dispute versus the importance of cost containment, something I'm sure we're all very familiar with. The more important a dispute or a license agreement is, the less of a concern there will likely be for cost containment. And the less important the dispute, the more concerned you may be with limiting the presentation of evidence, because it takes time. If you're paying for arbitrators' time, you're paying for attorneys' time, it tends to rack things up. And if you don't think the dispute will be as complicated or as important, that's one area where you can try to limit it and make sure things move along swiftly. One option that we have done in the past is to set up 2 different sets of procedures based on the value of the dispute. So within one arbitration clause, there can be 2 sets of provisions. For example, if the dispute is less than, say, $500,000, then there would only be one arbitrator, there will only be limited document discovery, there will be no depositions, and only a 2-day hearing. This is because for a dispute of this amount, it may not be worth it for the parties' time and money to do a proceeding that is more in-depth. Conversely, if the dispute is more than $500,000, then the arbitration provision may call for a 3-arbitrator panel where there are depositions taken, there's no limits or much higher limits for the presentation of evidence at the hearing. So there's a lot of different options of what you can put into the arbitration provision in order to help you out with the hearing itself. Next is the form of the award. Some parties want to ensure that there is a reasoned award, and they want to know why and how the panel reached their decision. This makes the panel show their work, and it forces them to think it through step by step and provide reasoning for their results. Frequently, when a reasoned award is requested, the parties will submit post-hearing briefing that includes a proposed findings of fact or a proposed conclusions of law for the panel to adopt. This allows the parties to lay it all out for the panel, but it is also more expensive to do all of that briefing after the hearing, and it also takes more time after the hearing is over to get a decision. So there's pluses and minuses as with all of these choices. Conversely, some parties prefer a bottom-line opinion where the panel just issues a one-liner to tell you what the result is. This is faster and is useful to parties that are especially concerned about confidentiality, as we mentioned before. That way, if you need to confirm the award in court, there's no risk of needing to file a reasoned opinion with the court that may become public and end up disclosing your confidential information. A third option is a little more creative, is baseball arbitration, where each party proposes a result and the arbitrators must choose one of the two proposed results. Now I'll hand it back to Jim one last time to address release.
Our arbitration clause checklist includes two final items. The one is the scope of relief, which should be addressed in any arbitration clause. Here again, there are a range of alternatives, and the merits of the alternatives will depend on the facts and circumstances relating to the license. One alternative is to leave the scope of relief to the discretion of the arbitrators. Another option is to bar certain types of damages, such as punitive damages. A third option is to bar or require the award of attorney's fees. A fourth option is to authorize an award of attorney's fees only with certain types of motions. For example, a motion challenging the award or seeking to vacate the award may include a fee-shifting provision. And then finally, we have the baseball arbitration option that Dara mentioned, in which the arbitrator must choose one of the parties' proposed awards. Now, the type of agreement that the parties enter into will dictate which of these provisions or these options are attractive to them. Bear in mind that a license agreement contemplates a beneficial and in many cases a long-standing relationship between the parties. It might be a joint venture, and in this circumstance, parties are going to be reluctant to include provisions that encourage disputes that might interfere with the productivity of the business relationship. So option number two, barring punitive damages, for example, might be very attractive in that circumstance because the parties will want to preserve, if possible, their long-standing business relationship, or at least not create incentives to undermine it. Similarly, an option requiring the award of attorney's fees can deter disputes and deter arbitration and therefore further the business interest of the parties. I mentioned that another way to achieve the same goal is to impose a fee-shifting requirement with certain types of motions. Finally, the baseball arbitration option is interesting because, number one, it eliminates the discretion of the arbitrators. They have a very simple choice. They have to choose one of the parties' proposed awards. They can't do anything in between under this option. And baseball arbitration, in the view of many, promotes settlement. Why? Because if the parties take hardline positions, they run the risk that the arbitrator will be incentivized to take the other party's position. So a hardline position is less likely to be taken in the case of baseball arbitration for the simple reason that it's less likely to be accepted by the arbitrator. So all of these are illustrations of the options that are available to the parties in crafting an arbitration clause dealing with the scope of relief that's consistent with their business objectives. The final item on our arbitration clause checklist addresses interim and equitable relief. We've talked about these options in the context of some of the strategic decisions that have to be made by the parties during the course of an arbitration. The alternatives include a provision that would allow the parties to apply to a court for equitable relief to protect their rights under the agreement. Another option is to permit the arbitrator to award equitable relief. You can have a provision that bars or limits injunctive or equitable relief. And finally, you can provide that the administrator's emergency arbitrator provisions will be applicable. I want to return to the option of applying to a court for an equitable relief, because I find that in many circumstances this can be attractive. As Dara noted, the availability of equitable relief from a court can serve as a kind of hedge against an arbitrary decision by an arbitrator, at least to the extent that the court will be in a position to provide equitable relief that's independent of the arbitrator's decision. And also the court proceeding can serve as a source of additional discovery if either of the parties need it. So all of this illustrates the creative options that are available to the parties in crafting arbitration clauses and license agreements, and it also underscores the importance of giving thought to what provisions you include in your arbitration clause, because you will have to deal with those provisions on the back end if a dispute arises. I see that we've had several questions that have been sent to us during the presentation, and we will be delighted to respond by email or phone to those and any other inquiries that any of the participants may have. We can also provide sample arbitration clauses incorporating any of the provisions that we discussed in the webinar. This concludes today's webinar on resolving license disputes through arbitration, U.S. and international. We hope the information shared today was useful. We thank you for your participation and have a great day.